Doctrine of Severability. Meaning of the doctrine. The doctrine of severability is also known as the doctrine of separability. This doctrine was devised by the Supreme Court to resolve the problem of the validity of laws which are declared as unconstitutional. When a part of the law is declared as institutional, then a question arises whether the whole of the law is to be declared void or only that part of the law, which is unconstitutional, should be declared as void. According to this doctrine, if the offending provision of the law can be separated from that provision which is constitutional, then only that part of the law, which is offending, is to be declared as void and not the whole of the law. Law. In other words, if the invalid part of the law can be separated from the rest, then the rest may continue to be valid and operative. If, however, it is not possible to separate the valid part of the law from the invalid part, then the whole of the law is declared as void. Basis of the doctrine. Article 13 is the basis of the doctrine of severability. It makes the following two provisions in this regard. 1. Article 13(1) deals with the pre-constitution laws and declares that all such laws are void to the extent to which they are inconsistent with the fundamental rights. Article 13(1) reads as follows. 1. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. Important doctrines of Important doctrines of constitutional interpretation. 2. Article 13(2) deals with the post-constitution laws and prohibits the state from making a law which takes away or abridges the fundamental rights, and any such law is void to the extent of the contravention. Only that portion of a law, which violates the fundamental rights, can be declared as void and not the whole of it. The Supreme Court has explained the doctrine of severability in the following way. The question whether a statute which is void in part is to be treated as void in toto, or whether it is capable of enforcement as to that part which is valid. The answer to this question must depend on whether what is valid could be separated from what is invalid, and that is a question which has to be decided by the court on a consideration of the provisions of the Act. Propositions of the doctrine. The Supreme Court has laid down the following propositions, rules, regarding the doctrine of severability. 1. In determining whether the valid parts of a statute are separable from the invalid parts thereof, it is the intention of the legislature that is the determining factor. The test to be applied is whether they. Article 13(2) reads as follows. 2. The state shall not make law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. RMD. Chamar Bagwallah vs. Union of India, 1957. Ibid. Legislature would have enacted the valid part if it had known that the rest of the statute was invalid. 2. If the valid and invalid provisions are so inextricably mixed up that they cannot be separated from one another, then the invalidity of a portion must result in the invalidity of the Act in its entirety. On the other hand, if they are so distinct and separate that after striking out what is invalid, what remains is in itself a complete code independent of the rest, then it will be upheld notwithstanding that the rest has become unenforceable. 3. Even when the provisions which are valid are distinct and separate from those which are invalid, if they all form part of a single scheme which is intended to be operative as a whole, then also the invalidity of a part will result in the failure of the whole. 4. Likewise, when the valid and invalid parts of a statute are independent and do not form part of a scheme, but what is left after omitting the invalid portion is so thin and truncated as to be in substance different from what it was when it emerged out of the legislature, then also it will be rejected in its entirety. 5. The separability of the valid and invalid provisions of a statute does not depend on whether the law is enacted in the same section or different section. It is not the form, but the substance of the matter that is material, and that has to be ascertained on an examination of the Act as a whole and of the setting of the relevant provision therein. 6. If after the invalid portion is expunged from the statute what remains cannot be enforced without making alterations and modifications therein, then the whole of it must be struck down as void, as otherwise it will amount to judicial legislation. 7. In determining the legislative intent on the question of separability, it will be legitimate to take into account the history of the legislation, its object, the title and the preamble to it. Important cases. The important cases relating to the doctrine of severability and their judgments are given in Table 91.1. Doctrine of waiver. Meaning of the doctrine. The doctrine of waiver is based on the premise that a person who is entitled to a right or privilege is at liberty to waive or give up that right or privilege. It is a voluntary renunciation of a known right or privilege. The doctrine of waiver is defined in the following way. Waiver is an intentional relinquishment of a right. It involves conscious abandonment of an existing legal right, advantage, benefit, claim or privilege, which except for such a waiver, a party could have enjoyed. In fact, it is an agreement not to assert a right. There can be no waiver unless the person who is said to have waived is fully informed as to his rights and with full knowledge about the same, he intentionally abandons them. It must be noted here that the doctrine of waiver is not applicable to the fundamental rights in India. In other words, a citizen cannot waive his fundamental rights in India. On the other hand, the doctrine of waiver is applicable to the fundamental rights in USA. In other words, an American citizen can. Paragraph 7 requires ratification under the proviso to Article 3682, for excluding the jurisdiction of high courts under Article 226 and Supreme Court under Article 136. Surendra Malik and Sudeep Malik, Supreme Court on Doctrines and Maxims, Eastern Book Company, 2014, pp. 697 to 698. Sa. Important Doctrines of Constitution Interpretation. 649. Waive his fundamental rights. In short, there is the doctrine of non-waiver in India. 2. Position in India. With respect to the application of the doctrine of waiver to India, the Supreme Court made the following observations. 1. Fundamental rights cannot be waived by a citizen. They are mandatory on the state and necessary to attain the objectives enshrined in the preamble. Hence, no citizen can relieve the state of this obligation which is imposed on it by the Constitution. 2. The doctrine of waiver enunciated by some American judges in construing the American Constitution cannot be introduced in our Constitution. 3. The fundamental rights have not been put in the Constitution merely for individual benefit, though ultimately, they come into operation in considering individual rights. They have been put there, as a matter of public policy, and the doctrine of waiver can have no application to provisions of law, which have been enacted as a matter of constitutional policy. 4. Reference to some of the articles, inter alia, Articles 15, 1, 20, 21, makes the proposition quite plain. A citizen cannot get discrimination by telling the state, you can discriminate, or get convict by waiving the protection given under Articles 20 and 21. Basheshwar Nath vs. Commissioner of Income Tax, 1958. Be void. Article 13, 1. Whatever be the position in America, no distinction can be drawn here, as has been attempted in the United States of America, between the fundamental rights which may be said to have been enacted for the benefit of the individual and those enacted in public interest or on grounds of public policy. 6. Ours is a nascent democracy, and situated as we are, socially, economically, educationally, and politically, it is the sacred duty of the Supreme Court to safeguard the fundamental rights. Important cases. The important cases relating to the doctrine of waiver and their judgments are given in Table 91.2. Doctrine of eclipse. Meaning of the doctrine. The prospective nature of the provision under Article 13, 1, of the Constitution has led to the emergence of the doctrine of eclipse. This provision deals with the pre-Constitution laws and declares that all such laws are void to the extent to which they are inconsistent with fundamental rights. The doctrine of eclipse is based on notion that a pre-constitutional law which is inconsistent with a fundamental right not a nullity or void from its very insistence. Such a law becomes only inoperant from the date of the commencement of Constitution. It is overshadowed or eclipsed by the fundamental right and remains dormant but is not dead altogether. It is wiped out completely from the statute book. It continues to exist, I, for all past transactions. E, for the enforcement of right acquired and liabilities incurred before the date of the commencement of the Constitution. And E, for the determination rights of non-citizens who have not been given the fundamental rights by the Constitution. Thus, it does not become void toto, or for all purposes or for all times for all persons. Article 13, 1, reads as follows. 1. All laws intra in the territory of India immediately before commencement of this Constitution, insof they are inconsistent with the provisions of this pet shall, to the extent of such inconsistency, be void. However, if the shadow cast on such a law by the relevant fundamental right is removed by an amendment of the Constitution, then the law would again become constitutional and enforceable. In other words, the amendment of the fundamental right makes the impugned law free from all blemish or infirmity. Formulation of the doctrine. The doctrine of eclipse was enunciated by the Supreme Court in the Bhikaji case, 1955. In this case, Section 43 of the Motor Vehicles Act, 1939, was amended by the Central Provinces and Berar Motor Vehicles Amendment Act 1947. This provision empowered the state government to take over the motor transport business to the exclusion of individual operatians. But it became void with the commencement of the Constitution in 1950 as it violated the fundamental right under Article 19(1)(g). Later, the First Amendment Act, 1951, amended Article 19(6) and enabled the government to take over any trade or business either exclusively or in competition with the individuals. Consequently, the state government issued a notification to take over the motor transport business. This notification was challenged in the Supreme Court. The state government argued that from January 26, 1950 to June 18, 1951, Section 43 of the Motor Vehicles Act, 1939, remained invalid, but the amendment of the provision under Article 19(6) by the First Amendment Act, 1951, made the same Section 43 of the Act valid again. Finally, the Supreme Court held that the impugned Act became, for the time being, eclipsed by the fundamental right, but the amendment of Article 19(6) removed the shadow. In other words, the court upheld the validity of the notification by applying the doctrine of eclipse. Application to post-constitutional laws. Article 13(1) deals with the pre-constitution laws, while Article 13(2) deals with the post-constitution laws. The latter prohibits the Bhikaji Narendra Dhakra's vs. State of MP. 1995. State from making a law which takes away or abridges the fundamental rights, and any such law is void to the extent of the contravention. In Deep Chand case, 1959, the Supreme Court held that the doctrine of eclipse applies only to the pre-constitution laws and not to the post-constitution laws. This is because, a post-constitution law which contravenes a fundamental right is a nullity or void from its very inception and a stillborn law. Therefore, it cannot be revived by a subsequent constitutional amendment. Accordingly, the court upheld the constitutionality of the Uttar Pradesh Transport Service Development Act, 1955, saying that it did not violate Article 31 of the Constitution. In Mahendra Lal Jain case 13, 1962, the Supreme Court reiterated its verdict delivered in Deep Chand case, 1959, and held that the doctrine of eclipse cannot be applied to the post-constitution laws. The court observed, the doctrine of eclipse will apply to pre-constitution laws which are governed by Article 13(1), and would not apply to post-constitution laws which are governed by Article 13(2). Unlike a law governed by Article 13(1), which was valid when made, the law made in contravention of the prohibition contained in Article 13(2) is a stillborn law, either wholly or partially, depending upon the extent of the contravention. Such a law is dead from the beginning, and there can be no question of its revival under the doctrine of eclipse. However, the position in Ambika Mills case 15, 1974, was different. In this case, the Supreme Court reversed its earlier stand and applied the doctrine of eclipse even to a post-constitution law. The court held that a post-constitution law which violates the Article 13(2) reads as follows: 2. The state shall not make law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. 12. Deep Chand vs. State of UP. 1959. 13. Mahendra Lal Jain vs. State of UP. 1962. Deep Chand vs. State of UP. 1959. 15. State of Gujarat vs. Shri Ambika Mills Limited. 1974. 30. Fundamental rights is not a nullity or void in all cases and for all purposes. Further, it said that there are many exceptions to the doctrine of absolute nullity, and hence, it cannot be regarded as a universal rule. A post-constitution law which violates the fundamental right conferred by Article 19 will be effective as regards to non-citizens because fundamental rights are not conferred on them. On the other hand, such a law will become a nullity or void only against citizens because fundamental rights are available to them. Accordingly, the Bombay Labour Welfare Fund Act, 1953, was held to be valid and operative with regard to non-citizens. Later, the Supreme Court applied the doctrine of eclipse to a post-constitution law even against citizens in Dulare Lode Case 16, 1984. Doctrine of Territorial Nexus. Meaning of the doctrine. The doctrine of territorial nexus is rated to RTCLA 245, which deals with the extent of laws made by the Parliament and the state legislatures. It contains the following provisions. 1. The Parliament is empowered to make laws for the whole or any part of the territory of India. In addition, it can also make extraterritorial legislation. This implies that the parliamentary laws are applicable not only to the persons and property within the territory of India but also to the Indian citizens and their property in any part of the world. 2. A state legislature is empowered to make laws for the whole or any part of the state. Unlike the parliament, a state legislature cannot make extraterritorial legislation. From the above, it is clear that the laws made by a state legislature are not applicable outside the state. However, there is one exception to this general rule, i.e., an extraterritorial. 16 Dulare Lode vs. 3rd Additional District Judge, Kanpur, 1984. Legislation made by a state legislature is valid when there is a sufficient nexus between the state and the object. This is known as the doctrine of territorial nexus. According to the doctrine of territorial nexus, the object to which a state law applies need not be physically located within the state territory, but it is required that there should be a sufficient nexus or connection between the state and the subject matter of the law. This means that a state law having extraterritorial operation is held valid by applying the doctrine of territorial nexus. 2. Formulation of the doctrine. In the pre-constitution period, there were three important cases in which the doctrine of territorial nexus was applied. The Federal Court applied the doctrine in Raleigh Case, 1944, and Wadia Case 8, 1949, while the Privy Council applied it in Wallace Cases 19, 1948. These three cases were related to the income tax law. In the post-constitution period, the Supreme Court applied the doctrine in RMD. Chamarbagwala Case 20, 1957. This case was related to the law imposing a tax on gambling. In this case, the court held that if there is a sufficient territorial nexus between the person sought to be taxed and the state seeking to tax him, the taxing law is upheld. It also clarified that the sufficiency of territorial nexus involves a consideration of the following two important elements. 1. The nexus must be real and not illusory. And 2. The liability sought to be imposed must be relevant to that nexus. In Tisco Case, 1958, the Supreme Court applied the doctrine to the sales tax law. In 17 Governor General vs. Raleigh Investment Company, 1944. 18. A.H. Wadia vs. Commissioner of Income Tax, 1949. 19 Wallace Brothers and Company Limited vs. Commissioner of Income Tax, 1948. 20 State of Bombay vs. RMD. Chamarbagwala, 1957. Tata Iron and Steel Company vs. State of Bihar. 1958. The court observed that this doctrine does not impose the tax, but it only indicates the circumstances in which a tax imposed by a law shall be enforced in a particular case. In NTPC Case, 2002, the Supreme Court has explained the doctrine in the following way. It is by reference to the ambit or limits of territory by which the legislative powers vested in Parliament and the state legislatures are divided in Art. 245. Generally speaking, a legislation having extraterritorial operation can be enacted only by Parliament and not by any state legislature. Possibly the only exception being one where extraterritorial operation of a state legislation is sustainable on the ground of territorial nexus. Such territorial nexus, when pleaded, must be sufficient and real and not illusory. 3. Application to non-tax laws. The doctrine of territorial nexus is applicable not only to tax laws like income tax law imposing a tax on gambling, and sales tax law, but also to other kinds of laws. Thus, in Charusila Dasi Case 23, 1959, the Supreme Court held that a state legislature is empowered to make laws with respect to charitable and religious trusts situated within the territory of the state, even though some part of the trust property is situated in another state. As a natural corollary to this, the state legislature is also empowered to make laws in respect of the trustees, their servants and agents who are in that state to administer the trust. Accordingly, the court upheld the validity of a law made by the Bihar legislature with respect to trust property situated in the state of West Bengal. Likewise, in Shrikant case, 1994, the Supreme Court held that the Gujarat state was empowered to make the law so as to provide that the selling of agricultural land of a state of AP versus National Thermal Power Corporation Limited 2002. State of Bihar vs. Charusila Dasi, 1959. Shrikant Bhalchandra Karulkar vs. State of Gujarat, 1994. Person in that state could be determined by taking into account the agricultural land held by him outside that state also. Accordingly, the court upheld the validity of the Gujarat Agricultural Land Ceiling Act, 1960. 4 exceptions to the doctrine. The doctrine of territorial nexus is not applicable in the following 2 situations. 1. When a state government, while acting under the Motor Vehicles Act of central legislation, approves a scheme for interstate routes for the state transport undertaking. In Khazan Singh Case 25, 1973, the Supreme Court upheld the validity of a Uttar Pradesh scheme nationalizing certain routes between that state and the state of Rajasthan. 2. When a state carry on trade and business under the provision of Article 298. In the same Khazan Singh Case 26, 1973, the Supreme Court held that the trade and business to be carried on by a state need not be restricted to the area within its boundaries. Doctrine of Pith and Substance. Meaning of the doctrine. Article 246 deals with the division of legislative powers between the Parliament and the state legislatures. It specifies the different subjects of legislation in 3 lists, namely, List I, Union List, List 2, State List, and List 3, Concurrent List. Accordingly, the Parliament or a state legislature should make laws within their respective jurisdictions and should not encroach upon the other sphere. If it encroaches, then the validity of the law enacted by it is determined by applying the doctrine of pith and substance. According to this doctrine, a law in question must be looked into as an organic whole and not as a mere collection of sections. For Khazan Singh vs. State of UP, 1973. 26 Ibad. Determining the true nature and character of the impugned law, i.e., the pith and substance of the law. If it is found that the pith and substance of the impugned law relates to the subject within the domain of the legislature enacting the law, then the law would be held valid even though it incidentally encroaches on subjects which have been assigned to another legislature. Further, for applying the doctrine, one must have regard, a, to the enactment as a whole, b, to its main objects, and c, to the scope and effect of its provisions. 2. Rationale of the doctrine. The doctrine of pith and substance was evolved by the Privy Council when it determined appeals from Canada or Australia involving the question of legislative competence of the centre, or the states in those federations. Later, this doctrine came to be established in India where it derives its genesis from the approach adopted by the courts including the Privy Council in dealing with controversies arising in other federations. While explaining the rationale of the doctrine, the Supreme Court made the following observation too. It must be remembered that we are construing a federal constitution. It is of the essence of such a constitution that there should be a distribution of the legislative powers of the federation between the center and the provinces. The scheme of distribution has varied with different constitutions, but even when the constitution enumerates elaborately the topics on which the center and the states could legislate, some overlapping of the fields of legislation is inevitable. 3. Principles of the doctrine. In the pre-constitution period, the doctrine of pith and substance was applied by the Privy Council in Prafulla Kumar case, 1947. This 27 AS. Krishna vs. State of Madras, 1956. 28 Prafulla Kumar Mukherjee vs. Bank of Commerce, 1947. Case involved the interpretation of the Division of Powers under the Government of India Act, 1935. In this case, the validity of the Bengal Money Lenders Act, 1946 was challenged on the ground that it was ultra vires the Bengal legislature insofar as it related to promissory notes, which was a central subject. The Calcutta High Court held the act to be intra vires while the Federal Court, on appeal, reversed it. Finally, the Privy Council held that the act was, in pith and substance, a law in respect of money lending and money lenders, a state subject and hence, was valid even though it incidentally encroached on promissory notes. In the above case, the Privy Council laid down the following principles of the doctrine of pith and substance. 1. It is not possible to make a clear-cut demarcation between the powers of the federal legislature and the provincial legislature. The powers are bound to overlap from to time. Where they overlap, the questions must be asked are A. What, in pith and substance, is the effect of the enactment of which complaint is made? B. In what list is its true nature and character to be found? If these questions could not be asked, much beneficent legislation would be stifled at birth, and many of the subjects entrusted to the provisional legislature could never effectively be dealt with. 2. The extent of the invasion by the provinces into subjects enumerated in the federal list has to be considered. No doubt it is an important matter, not because the validity of an act can be determined by discriminating between degrees of invasion, but for the purpose of determining what is the pith and substance of the impugned act. 3. Where the three lists come in conflict, List I has priority over Lists 3 and 2, and List 3 has priority over List 2. But, the question still remains, priority in what respect? Does the priority of the federal legislature prevent the provincial legislature from dealing with any matter? It may incidentally affect any item in its list, or in each case has one to consider what the substance of the act is and, whatever its ancillary effect, attribute it to the appropriate list according to its true character. The latter is the true view. In the post-Constitution period, the Supreme Court has consistently applied the above principles in a number of cases. Important cases. The important cases relating to the doctrine of pith and substance and their judgments are given in Table 91.3. Doctrine of colorable legislation. Meaning of the doctrine. The Constitution, under Article 246, provides for the division of legislative powers between the Parliament and the state legislatures. It enumerates the legislative subjects in three lists, namely, the Union list, the state and the concurrent list under the 7th Schedule. Both are required to operate within their respective legislative competence. But, sometimes, a legislature makes a law which, though in form appears to be within its competence, in effect and substance lies beyond its ambit. Then the law would be declared as void. In other words, the different color given to the law, by the legislature so as to bring it within its ambit, would not save it from being declared as invalid. Such a law is called as colorable legislation. Colorable legislation would emerge only when a legislature had no power to legislate on an item either because it was not included in the list assigned to it under the respective entries in the 7th Schedule, or on account of limitations imposed whether under Part 3 of the Constitution, relating to colorable legislation would emerge only when a legislature had no power to legislate on an item either because it was not included in the list assigned to it under the respective entries in the 7th Schedule, or on account of limitations imposed whether under Part 3 of the Constitution, relating to the fundamental rights, or any other power under the Constitution. The whole doctrine of colorable legislation is based upon the maxim that, you cannot do indirectly, what you cannot do directly, i.e., what cannot be done directly, cannot also be done indirectly. This means that the use of the expression, colorable legislation, seeks to convey that by enacting the legislation in question, the legislature is seeking to do indirectly what it cannot do directly. 2. Propositions of the doctrine. The Supreme Court has laid down the following propositions in respect of the doctrine of colorable legislation. 1. If the Constitution distributes the legislative powers amongst different legislative bodies, which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect of the subject matter of the statute or in the method of enacting it, transgressed the limits of its constitutional powers. Such transgression may be patent, manifest or direct, but it may also be disguised, covert and indirect, and it is to this latter class of cases that the express sign, colorable legislation, has been applied in judicial pronouncements. 2. The idea conveyed by the expression that although apparently a legislature in passing a statute purported to act within the limits of its powers, yet in substance and in reality it transgressed these powers, the transgression being veiled by what appears, on proper examination, to be a mere pretense or disguise. 3. It is the substance of the act that is made real and not merely the form or outward appearance, and if the subject matter. K.C. Gajapati Narayan Dovs. State of Orissa, 1953. In substance is something which is beyond the powers of that legislature to legislate upon, the form in which the law is clothed would not save it from condemnation. 4. The legislature cannot violate the constitutional prohibitions by employing an indirect method. In cases like these, the inquiry must always be as to the true nature and character of the challenged legislation, and it is the result of such investigation and not the form alone that will determine as to whether or not it relates to a subject which is within the power of the legislative authority. For the purpose of this investigation, the court would certainly examine the effect of the legislation and take into consideration its object, purpose, or design. But these are only relevant for the purpose of ascertaining the true character and substance of the enactment and the class of subjects of legislation to which it really belongs, and not for finding out the motives which induced the legislature to exercise its powers. 5. The doctrine of colorable legislation does not involve any question of bona fides or mala fides on the part of the legislature. The whole doctrine resolves itself into the question of competency of a particular legislature to enact a particular law. If the legislature is competent to pass a particular law, the motives which impelled it to act are really irrelevant. On the other hand, if the legislature lacks competency, the question of motive does not arise at all. Whether a statute is constitutional or not is thus always a question of power. 6. A court must be blind indeed if it looks merely at the language of a statute and ignores its obvious purpose, effect, and operation. Hence, when a statute is impugned as being a mere colorable device to evade constitutional provisions, the court is required to scrutinize in its entirety the impugned statute as well as. Hence, when her bills or acts which may form part of a scheme for such evasion, for the purpose of ascertaining the true nature and character, or pith and substance, of the impugned statute. Sometimes, it may so happen that statute, when considered independently, may be free from any objection, but if it could be shown that it is part of a general scheme on the part of the legislature, by a series of acts to achieve an object which it could not well idly achieve in one piece of legislation, the statute would also be struck down as unconstitutional. 3. Doctrine of fraud on the Constitution. The doctrine of colorable legislation is also known as the doctrine of fraud on the Constitution. The Supreme Court, in this context, has made the following observation. Colorable piece of legislation is a legislation ostensibly under one or the other of the powers conferred by the Constitution, but in substance and reality, not falling within the content of that power. The failure to comply with a constitutional condition for the exercise of legislative power may be overt or it may be covert. When it is overt, we say the law is obviously bad for non-compliance with the requirements of the Constitution, that is to say, the law is ultra vires. When, however, the non-compliance is covert, we say that it is a fraud on the Constitution, the fraud complained of being that the legislature pretends to act within its power while in fact it is not so doing. Therefore, the charge of fraud on the Constitution is, on ultimate analysis, nothing but a picturesque and epigrammatic way of expressing the idea of non-compliance with the terms of the Constitution. 30 State of Bihar vs. Kameshwar Singh, 1952. 4. Doctrine of fraud on legislative power. It must be noted here that the doctrine of fraud on the Constitution is different from the doctrine of fraud on legislative power. The Supreme Court, while explaining this distinction, made the following observation. 1. The doctrine of fraud on legislative power means that the legislature really has the power, but does not exercise that power. It merely pretends to have exercised the power. In the eye of law, such an act is not a law at all, but is a mere pretense of law, and the courts will not take notice of such a law. 2. The doctrine of fraud on the Constitution is altogether a different principle and a serious charge. When there is a constitutional prohibition to make an act, but the legislature, in spite of the constitutional prohibition, enacts such a law, it is a fraud on the Constitution. Therefore, the distinction between the fraud on legislative power and fraud on the Constitution is clear and unambiguous. 3. The principle of fraud on legislative power is applicable when the legislature has power to enact, but has not exercised that power as envisaged upon. On the other hand, the doctrine of fraud on the Constitution means that when the legislature has no power and in spite of the constitutional prohibition, it makes an enactment in pretense of or purported exercise of the power. It would, therefore, be necessary to examine these concepts in the light of the related subject, the legislative history, the respective entries in the lists concerned of the 7th schedule in the power of the legislature to determine whether the legislature has competence to enact law or enacted it by playing a fraud on the Constitution, colorable exercise of power. S.S. Bowler vs. B.D. Sarlana, 1997. Able 91.4 Important cases relating to the doctrine of colorable legislation. SL. No. 1. Case, year. State of Bihar vs. Kameshwar Singh, 1952. KC. Gajupati Narayan Do vs. State of Orissa, 1953. KT. Mupal Nair vs. State of Kerala, 1960. MR. Balaji vs. State of Mysore, 1962. Doctrine of implied powers. Meaning of the doctrine. The doctrine of implied powers is also known as the doctrine of implication. This doctrine is based on the maxim that whoever grants a thing is deemed also to grant that without which the grant itself would be of no effect. According to the Black's Law Dictionary, the term implied power means a political power that is not enumerated but that nonetheless exists because it is needed to carry out an express power. While defining the doctrine of implied powers, Craze observed, one of the first principles of law with regard to the effect of an enabling act is that if a legislature enables something to be done, it gives power at the same time by necessary implication to do everything which is indispensable for the purpose of carrying out the purposes in view. Similarly, C.B. Pollock, while dealing with this doctrine, said, whenever anything is authorized, and especially if, as matter of duty, required to be done by law, and it is found impossible to do the thing unless something else not authorized in express terms be also done, then that something will be supplied by necessary intendment. This doctrine can be invoked in cases where an act confers a jurisdiction. It also confers by implication the power of doing all such acts, or employing such means as are essentially necessary to its execution. Scope of the doctrine. The Supreme Court has explained the scope and effect of the doctrine of implied powers in the following way. The doctrine of implied powers can be legitimately invoked when it is found that a duty has been imposed or a power conferred on an authority by a statute, and it is further found that the duty cannot. Michele Fenton and James Fraser vs. John Stephen, Hempton, 1858. Biddy Leaves and Tobacco Merchants Association. Be discharged that the power cannot be exercised at all unless some auxiliary or incidental power is assumed to exist. In such a case, in the absence of an implied power, the statute itself would become impossible of compliance. The impossibility in question must be a general nature, as that the performance of duty or the exercise of power is rendered impossible in all cases. It really means that the statutory provision would become a dead letter and cannot be enforced unless a subsidiary power is implied. Application of the doctrine. The Supreme Court has applied the doctrine of implied powers in a number of constitutional cases. The important among them are as follows. In Gopal Chandra Misra case, 1978, the Supreme Court held that a judge of a state high court has an implied power under the provisions of Article 217 to revoke his resignation even after his resignation letter has been received. In Rupa Ashok Hara cases, 2002, the Supreme Court held that it has an implied power, i.e., inherent power, which enables it to reconsider its own judgments. It suggests that a curative petition can be filed for seeking reconsideration of a judgment that has become final after dismissal of a review petition under the provisions of Article 137. It said that a curative petition is allowed in order to cure a gross miscarriage of justice and to prevent abuse of its process. In Raja Rampal case 36, 2007, the Supreme Court held that the Parliament has an implied power under the provisions of Article 105 to expel its members for its contempt. In Salil Sublock case, 2013, the Supreme Court held that Article 316, which grants a Union of India vs. Gopal Chandra Misra, 1978. Rupa Ashok Hara vs. Ashok Hara, 2002. Raja Rampal vs. Speaker of the Lok Sabha, 2007. State of Punjab vs. Salil Sublock, 2013. 4. Important Doctrines of Constitutional Interpretation. 659. State Governor the power to appoint the members of the State Public Service Commission, SPSC, also grants the implied power to lay down the procedures for such appointments. 4. Doctrine of Implied Prohibition. The doctrine of implied prohibition is the opposite of the doctrine of implied powers. This doctrine is based on the maxim that express mention of one thing implies the exclusion of another. The doctrine of implied prohibition is applied in USA and Australia. In these federal countries, only the powers of the central legislature are enumerated in the Constitution and the residuary powers have been left to the state legislature. This means that there is an implied prohibition on the central legislature to make laws on the residuary subjects. However, this prohibition is not applicable to those encroachments on the residuary powers of the state legislature, which are incidental and ancillary to the proper execution of the express powers granted to the central legislature. The doctrine of implied prohibition is not applicable in India. In the Indian Constitution, the powers of both the central legislature and the state legislature have been separately enumerated. The Parliament can legislate on the subjects enumerated in the Union list, concurrent list, and also on the residuary subjects. On the other hand, a state legislature can legislate on the subjects enumerated in the state list and concurrent list. However, the doctrine of incidental and ancillary powers is applied in India also. Doctrine of incidental and ancillary powers. Meaning of the doctrine. The legislative powers of the Parliament and the state legislatures are mentioned in the 7th schedule of the Constitution. Every such power, i.e., expressly mentioned legislative power, carries with it the incidental or ancillary power which is necessary to execute that power. In other words, the incidental and ancillary powers are those powers which are required to be exercised by the legislatures for the effective exercise of legislative powers expressly bestowed on them by the Constitution. In USA, such powers are called as necessary and proper powers, while in Australia, they are described as powers incidental to the execution of that power. According to this doctrine, the entries enumerated in the 3 legislative lists are not to be read in a narrow or restricted sense, and each general word in an entry should be held to extend to all incidental or ancillary matters which can fairly and reasonably be comprehended in it. Hence, the power to levy tax would include the power to make provisions for checking tax evasion. Similarly, the power to legislate with respect to collection of rent includes the power to legislate with respect to remission of rent. However, the above logic of wider interpretation does not mean that the scope of the 36th the American Constitution describes the incidental or ancillary powers of the Congress in the following way. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Justice Gajendra Gadkar, while explaining the 39 doctrine of incidental and ancillary powers, made the following observation. It is an elementary cardinal rule of interpretation that the words used in the Constitution which confer legislative power must receive the most liberal construction, and if they are words of wide amplitude, they must be interpreted so as to give effect to that amplitude. It would be out of place to put a narrow or restricted construction on words of wide amplitude in a constitution. A general word used in any entry must be construed to extend to all ancillary or subsidiary matters which can fairly and reasonably be held to be included in it. 40 Commissioner of Commercial Taxes vs. R.S. Javer, 1967. United Provinces vs. Atika Begum, 1941. Incidental or ancillary power can be extended to any unreasonable extent. Hence, the power to levy tax cannot be held to include the power to confiscate goods. Further, this doctrine cannot be used as a cloak for extending the power of a legislature so as to comprehend a subject which is explicitly mentioned in a list. For example, the legislative power in respect of betting and gambling, in entry 34 of the state list does not include the power to impose taxes on betting and gambling, which is explicitly mentioned as a separate subject in entry 62 of the state list. Moreover, this doctrine cannot be extended to the exercise of the legislative power color ably or by fraud on the Constitution. 2. Rationale of the doctrine. The Supreme Court has founded the doctrine of incidental and ancillary powers to relieve a statute from its invalidity or unconstitutionality. The court, while explaining the rationale of the doctrine, made the following observation. The courts have applied the doctrine of pith and substance, and in some cases the doctrine of incidental, or ancillary, or subsidiary power of the legislature to uphold the law or to validate the law declared by the courts as invalid. Thereon, one of the doctrines is applied when the court finds that the law in pith and substance is within the legislative competence but incidentally trenches upon another subject of legislation. Equally, the doctrine of ancillary or subsidiary power of the legislature is applied when the court records a finding that the impugned act is substantially within the legislative competence, but incidentally it trenches upon another subject of legislation assigned either to Parliament or the legislature of a state, as the case may be. The doctrine of incidental or ancillary power is founded upon the principle that Check Post Officer vs. K.P. Abdullah, 1970. RMD. Chamar Bagwallah vs. State of Mysore, 1961. 44 SS. Bowler vs. B.D. Sardana, 1997. In a case where on the face of a statute, it appears that the legislative subject falls both in the union as well as the state list, but on a careful scrutiny it becomes clear that it falls merely incidentally in one list but substantially in another list. However, it cannot be regarded as the case of substantial encroachment trespassing into another field. The incidental encroachment, therefore, means that in enacting a legislation, the legislature has not traversed beyond the legislative field allotted to it by the arrangement of distribution of powers in the respective entries in the list concerned in the 7th schedule. 3 important cases. The important cases relating to the doctrine of incidental and ancillary powers and their judgments are given in Table 91.5. Doctrine of Precedent. Meaning of the doctrine. The doctrine of precedent, or the doctrine of stare decisis, is an English doctrine. According to this doctrine, the lower courts are bound by the decisions of the higher courts. Therefore, in Britain, every court is bound by the decisions of the House of Lords. It is a settled principle of law that a judgment, which has held the field for a long time, should not be unsettled. The doctrine of stare decisis is expressed in the maxim, stare decisis et non quieter movere, which means, to stand by decisions and not to disturb what is settled. Lord Coke aptly described this in his classic English version as, those things which have been so often adjudged ought to rest in peace. The underlying logic of this doctrine is to maintain consistency and avoid uncertainty. The guiding philosophy is that a view which has held the field for a long time should not be disturbed only because another view is possible. 45. The above point has been aptly described by the former Chief Justice Chandrachud in the following way. 46. It is sufficient for invoking the rule of stare decisis that a certain decision was arrived at on a question which arose or was argued, no matter on what reason the decision rests or what is the basis of the decision. In other words, 40. 45 Shankar Raju vs. Union of India, 2011. 46 Vaman Rao vs. Union of India, 1980. Purpose of applying the rule of stare decisis, it is unnecessary to inquire or determine as to what was the rationale of the earlier decision which is said to operate as stare decisis. 2. Basis of the doctrine. The doctrine of precedent has been incorporated in Article 141 of the Constitution. According to this provision, the law declared by the Supreme Court shall be binding on all courts within the territory of India. Hence, all the courts and tribunals including the high courts in India are required to follow the decisions of the Supreme Court. The Supreme Court has explained the significance of Article 141 of the Constitution in the following way. When the Supreme Court decides a principle, it would be the duty of the High Court or a subordinate court to follow the decision of the Supreme Court. A judgment of the High Court which refuses to follow the decision and directions of the Supreme Court or seeks to revive a decision of the High Court which had been set aside by the Supreme Court is a nullity. According to the Supreme Court, it is impermissible for the High Court to overrule the decision of the Apex Court on the ground that the Apex Court laid down the legal position without considering any other point. The court further emphasized that it is not only a matter of judicial discipline for the high courts in India, but also a mandate of the Constitution as provided in Article 141 that the law declared by the Apex Court shall be binding on all courts in the country. Apart from Article 141 of the Constitution, the policy of courts is to stand by precedent and not to disturb settled point. When court has once laid down a principle of law is applicable to certain state of facts, it will adhere to. Director of Settlements, AP vs. M.R. Apario, 2002. 48 Suganti Suresh Kumar vs. Jagdishan, 2002. That principle, and apply it to all future cases where facts are substantially the same. A deliberate and solemn decision of court made after argument on question of law fairly arising in the case, and necessary to its determination, is an authority, or binding precedent in the same court, or in other courts of equal or lower rank in subsequent cases where the very point is again in controversy. 3. Rationale of the doctrine. In the hierarchical system of courts which exists in India, it is necessary for each lower tier, including the high courts, to accept loyally the decisions of the higher tiers. It is inevitable in a hierarchical system of courts that there are decisions of the Supreme Appellate Tribunal which do not attract the unanimous approval of all members of the judiciary. But the judicial system only works if someone is allowed to have the last word, and that last word, once spoken, is loyally accepted. The better wisdom of the court below must yield to the higher wisdom of the court above. That is the strength of the hierarchical judicial system. 50. While explaining the rationale of the doctrine of precedent, the Supreme Court made the following observation. Consistency is the cornerstone of the administration of justice. It is consistency which creates confidence in the system, and this consistency can never be achieved without respect to the rule of finality. It is with a view to achieve consistency in judicial pronouncements, the courts have evolved the rule of precedence, principle of stare decisis etc. These rules and principles are based on public policy, and if these are not followed by courts, then there will be chaos in the administration of justice. Krishna Kumar vs. Union of India, 1990. 50. Assistant Collector of Central Excise vs. Dunlop India Limited, 1984. Government of Andhra Pradesh vs. A.P. Jaiswal, 2000. The doctrine of binding precedent has the merit of promoting a certainty and consistency in judicial decisions, and enables an organic development of the law. The Supreme Court has enunciated the importance of the doctrine in the development of jurisprudence of law in the following way. 52. Taking note of the hierarchical character of the judicial system in India, it is of paramount importance that the law declared by this court should be certain, clear, and consistent. It is commonly known that most decisions of the courts are of significance not merely because they constitute an adjudication on the rights of the parties and resolve the dispute between them, but also because in doing so they embody a declaration of law operating as a binding principle in future cases. In this latter aspect lies their particular value in developing the jurisprudence of the law. While stating the importance of consistent opinions in achieving harmony in the judicial system, the Supreme Court observed as follows. It is true that in the system of justice, which is being administered by the courts, one of the basic principles which has to be kept in view is that courts of coordinate jurisdiction should have consistent opinions in respect of an identical set of facts or on a question of law. If courts express different opinions on the identical sets of facts or question of law while exercising the same jurisdiction, then instead of achieving harmony in the judicial system, it will lead to judicial anarchy. When a position in law is well settled as a result of the judicial pronouncements of the Supreme Court, it would amount to judicial impropriety on the part of subordinate courts. Union of India vs. Raghubir Singh, 1989. Hari Singh vs. State of Haryana, 1993. Including the High Courts to ignore the settled decisions and then to pass a judicial order which is clearly contrary to the settled legal position. The Supreme Court, in this context, observed as follows. Such judicial adventurism cannot be permitted, and we strongly deprecate the tendency of the subordinate courts in not applying the settled principles and in passing whimsical orders which necessarily has the effect of granting wrongful and unwarranted relief to one of the parties. It is time that this tendency stops. The Supreme Court cautioned that the judgments of this court are decisions between litigants but declaratory for the nation. This court further observed, enlightened litigative policy in the contrary must accept as final the pronouncements of this court unless the subject be of such fundamental importance to national life or the reasoning is so plainly erroneous in the light of later thought that it is wiser to be ultimately right rather than to be consistently wrong. Stare decisis is not a ritual of convenience but a rule with limited exceptions. Doctrine of occupied field. Meaning of the doctrine. The doctrine of occupied field says that when the Parliament enacts a law on a particular subject and thereby occupies the field, a state legislature will not have authority to make any law on that field. In other words, according to this doctrine, when a legislative field is already occupied by a central legislation, there would be no scope for a state legislation in that field. This doctrine is also known as the doctrine of covered field. Dwarikesh Sugar Industries Limited vs. Prem Heavy Engineering Works Limited, 1997. 35 Ganga Sugar Corporation vs. State of UP, 1979. If the matter is within the exclusive competence of the Parliament, i.e., Union List I, then the state legislature is prohibited to make any law with regard to the same. 56. Similarly, if any matter is within the exclusive competence of the state legislature, i.e., State List II, then it becomes a prohibited field for the Parliament. On the other hand, if the matter is enumerated in the concurrent list, list 3, then both the Parliament as well as the state legislature will have the competence to make the law. There may be a situation where a state legislature is making a law on a matter enumerated in the concurrent list. It may notice that the legislative field is already occupied by a law of the Parliament. Therefore, the doctrine of occupied field is relevant in the case of laws made with reference to entries in the concurrent list 5. In other words, the doctrine of occupied field can be applied only to the entries of the concurrent list 59. It must be noted here that the doctrine of occupied field originates from Article 254, which deals with the inconsistency, repugnancy, between laws made by the Parliament and the state legislature. 2. Doctrine of repugnancy. Article 254 declares that in case of any inconsistency between a parliamentary law and a state law in respect of matters enumerated in the concurrent list, the parliamentary law shall prevail and the state law shall be void to the extent of repugnancy. According to the Supreme Court, the repugnancy between the two laws may be ascertained on the following three principles. 60. Direct conflict, whether there is direct conflict between the two provisions. 56. Hindustan Lever vs. State of Maharashtra, 2003. 57 Thid. 5 Thid. 59 State of Rajasthan vs. Watan Medical in General. Sto, 2001. 60 Deep Chand vs. State of UP. 1959. Intended occupation, whether Parliament intended to lay down an exhaustive code in respect of the subject matter replacing the act of the state legislature. And occupied field, whether the law made by Parliament and the law made by the state legislature occupied the same field. In order to determine the question of repugnancy between the two laws, the Supreme Court laid down the following tests, propositions. 1. It must be shown that the two enactments contain inconsistent and irreconcilable provisions so that they cannot stand together or operate in the same field. 2. There can be no repeal by implication unless the inconsistency appears on the face of the two statutes. 3. Where the two statutes occupy a particular field, but there is room or possibility of both the statutes operating in the same field without coming into collision with each other, no repugnancy results. 4. Where there is no inconsistency but a statute occupying the same field seeks to create distinct and separate offenses, no question of repugnancy arises and both the statutes continue to operate in the same field. Article 254 also contains an exception to the above rule of repugnancy. It says that if the state law has been reserved for the consideration of the President and has received his assent, then the state law shall prevail over the parliamentary law and operates in that state as valid law. However, the Parliament may again supersede the state law, which has been assented to by the President, by subsequently enacting a law on the same matter. If the Parliament enacts such a law, then the state law would be void to the extent of repugnancy with the parliamentary law. 61 M. Karunanidhi vs. Union of India, 1979. Repugnancy outside the concurrent list. The question of repugnancy between the parliamentary legislation and state legislation arises in two ways. First, where the legislations, though enacted with respect to matters in their allotted spheres, overlap and conflict. Second, where the two legislations are with respect to matters in the concurrent list and there is a conflict. In both the situations, the parliamentary legislation will predominate. In the first, by virtue of non-obstant clause in Article 246(1). In the second, by reason of Article 254(1). 79. The Supreme Court has further explained the above points of repugnancy in the following way. The question of repugnancy under Article 254(1) between a law made by Parliament and a law made by the state legislature arises only in case both the legislations occupy the same field with respect to one of the matters enumerated in the concurrent list, and there is direct conflict between the two laws. It is only when both these requirements are fulfilled that the state law will, to the extent of repugnancy, become void. Article 254(1) has no application to cases of repugnancy due to overlapping found between List 2 on the one hand and List I and List 3 on the other. If such overlapping exists in any particular case, the state law will be ultra vires because of the non-obstant clause in Article 246(1). Doctrine of prospective overruling. Meaning of the doctrine. The doctrine of prospective overruling is an American doctrine. It was applied in India. State of Kerala vs. State of Kerala vs. M. S. Mar Aprim Kuri Company. Limited, 2012. Hochast Pharmaceuticals Limited vs. State of Bihar, 1983. For the first time by the Supreme Court in the Golaknath case, 1967. When a court overrules its earlier decision and announces a new ruling, it can restrict the application of the new ruling only to the future transactions so that the validity of the past transactions is not affected. This is known as the doctrine of prospective overruling. In other words, this doctrine enables a court to overrule an old precedent, stare decisis, from a future date only and not retrospectively. In the Golaknath case 65, 1967, the Supreme Court overruled its earlier verdicts delivered in the Shankari Prasad cases, 1951, as well as in the Sajjan Singh case 67, 1964. In both the cases, the Supreme Court held that the Parliament's amending power under Article 368 also includes the power to amend the fundamental rights guaranteed in Part 3 of the Constitution. Hence, a constitutional amendment act enacted to abridge or take away the fundamental rights is not void under Article 13(2). Later, in the Golaknath case, 1967, the Supreme Court held that the amending power under Article 368 cannot be used to abridge or take away the fundamental rights, and a constitutional amendment act is law within the meaning of Article 13(2). But, the Supreme Court applied the doctrine of prospective overruling and declared that this decision will have only prospective operation and not retrospective operation. This means that the Parliament will have no power from the date of this decision to amend any of the provisions of Part 3 of the Constitution so as to abridge or take away the fundamental rights enshrined therein. Further, the First Amendment Act, 1951, the Fourth Amendment Act, 1955 and the 17th Amendment Act, 1964 will continue to be valid for the future. 1. C. Golaknath vs. State of Punjab, 1967. 65 1 bit. Shankari Prasad Singh vs. Union of India, 1951. 66-67 Sajjan Singh vs. State of Rajasthan, 1964. 681. C. Golaknath vs. State of Punjab, 1967. Formulation of the doctrine. The Supreme Court negatived the contention in Golaknath case, 1967, that prospective overruling amounts to judicial legislation. Explaining the Blackstonian theory of law, i.e., judge discovers law and does not make law, and the efficacy of prospective overruling, the court made the following observation. The doctrine of prospective overruling is a modern doctrine and is suitable for a fast-moving society. It does not do away with the doctrine of stare decisis, but confines it to past transactions. It is true that in one sense the court only declares the law, ceteris customary or statutory or personal law. While in strict theory, it may be said that the doctrine involves the making of law, what the court really does is to declare the law but refuses to give retroactivity to it. It is really a pragmatic solution reconciling the two conflicting doctrines, namely, that a court finds the law and that it does make the law. It finds the law but restricts its operation to the future. It enables the court to bring about a smooth transition by correcting its errors without disturbing the impact of those errors on the past transactions. It is left to the discretion of the court to prescribe the limits of the retroactivity, and thereby the doctrine enables the court to mold the relief to meet the ends of justice. By the application of this doctrine, the past may be preserved and the future protected. 3 bases of the doctrine. The Supreme Court explained the legal and constitutional basis of the doctrine of prospective overruling in the following way. In India, there is no statutory prohibition against the court refusing to give retroactivity to the law declared by it. Indeed, the doctrine of res judicata precludes any scope for retroactivity in respect of a sub-ibad. The doctrine of res judicata precludes any scope for retroactivity in respect of a subject matter that has been finally decided between the parties. Further, the Indian court by interpretation reject retroactivity to statutory provisions though couched in general terms on the ground that they affect vested rights. The present case only attempts a further extension of the said rule against retroactivity. Our Constitution does not expressly or by necessary implication speak against the doctrine of prospective overruling. Indeed, Articles 32, 141 and 142 are couched in such wide and elastic terms as to enable this court to formulate legal doctrines to meet the ends of justice. The only limitation thereon is reason, restraint and injustice. Under Article 32, for the enforcement of the fundamental rights, the Supreme Court has the power to issue suitable directions or orders or writs. Article 141 says that the law declared by the Supreme Court shall be binding on all courts. And Article 142 enables it, in the exercise of its jurisdiction, to pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. These articles are designedly made comprehensive to enable the Supreme Court to declare law and to give such directions or pass such orders as are necessary to do complete justice. The expression, declared, is wider than the words, found or made. To declare is to announce opinion. Indeed, the latter involves the process, while the former expresses result. Interpretation, ascertainment, and evolution are parts of the process, while that interpreted, ascertained, or evolved is declared as law. The law declared by the Supreme Court is the law of the land. If so, there is no acceptable reason why the court, in declaring the law in supersession of the law declared by it earlier, could not restrict the operation of the law, as declared, to the future and save the transactions, whether statutory or oath otherwise, that were effected on the basis of the earlier law. To deny this power to the Supreme Court on the basis of some outmoded theory that the court only finds law but does not make it is to make ineffective the powerful instrument of justice placed in the hands of the highest judiciary of this country. Propositions of the doctrine. The Supreme Court laid down 3 propositions with respect to the doctrine of prospective overruling. The court, in this context, observed as follows. As this court for the first time has been called upon to apply the doctrine evolved in a different country, under different circumstances, it would like to move warily in the beginning and would lay down the following propositions. 1. The doctrine of prospective overruling can be invoked only in matters arising under our Constitution. 2. It can be applied only by the highest court of the country, i.e., the Supreme Court, as it has the constitutional jurisdiction to declare a law binding on all the courts in India. 3. The scope of the retroactive operation of the law declared by the Supreme Court superseding its earlier decisions is left to its discretion to be molded in accordance with the true ties of the cause or matter before it. 5. Rationale of the doctrine. The Supreme Court has explained the rationale of the application of the doctrine of prospective overruling in the following way. We have arrived at 2 conclusions, namely, 1. Parliament has no power to amend Part 3 of the Constitution so as to take away or abridge the fundamental rights. And 2. This is a fit case to invoke and apply the doctrine of prospective overruling. What then is the effect of our conclusion on the instant case? Having regard to the history of the amendments, their impact on the social and economic affairs of our country, and the chaotic situation that may be brought about by the sudden withdrawal at the stage of the amendments from the Constitution, we think that considerable judicial restraint is called for. We, therefore, declare that our decision will not affect the validity of the Constitution, 17th Amendment, Act, 1964, or other amendments made to the Constitution taking away or abridging the fundamental rights. We further declare that in future Parliament will have no power to amend Part 3 of the Constitution so as to take away or abridge the fundamental rights. According to the Supreme Court, 1. The prospective declaration of law is a device innovated by the apex court to avoid reopening of settled issues and to prevent multiplicity of proceedings. 2. It is also a device adopted to avoid uncertainty and avoidable litigation. 3. By the very object of prospective declaration of law, it is deemed that all actions taken contrary to the declaration of law prior to its date of declaration are validated. This is done in the larger public interest. 6. Criticism of the doctrine. While considering the various arguments made against the application of the doctrine of prospective overruling, the Supreme Court made the following observation. Let us now consider some of the objections to this doctrine. The objections are: 1. The doctrine involved legislation by courts. 2. It would not encourage parties to prefer appeals as they would not get. Baburam vs. C.C. Jacob, 1999. 731. C. Golaknath vs. State of Punjab, 1967. Any benefit therefrom. 3. The declaration for the future would only be better. 4. It is not a desirable change. And 5. The doctrine of retroactivity serves as a brake on court which otherwise might be tempted to be so facile in overruling. But in our view, these objections are not insurmountable. If a court can overrule its earlier decision, there cannot be any dispute. When the court can do so, there cannot be any valid reason why it should not restrict its ruling to the future and not to the past. Even if the party filing An appeal may not be benefited by it. In similar appeals which she may file after the change in the law, she will have the benefit. The decision cannot be obiter, for what the court in effect does is to declare the law, but on the basis of another doctrine restricts its scope. Stability in law does not mean that injustice shall be perpetuated. Continuation of the doctrine. It must be noted here that even though the judgment delivered in the Golik Nath case 76, 1967, was overruled in the Kesavananda Bharti case, 1973, the doctrine of prospective overruling was upheld and followed in several subsequent judgments. Moreover, the Supreme Court has also extended the application of the doctrine to the matters arising under the ordinary statutes as well. The judgment in Mandal case, 1992, postponing the operation for 5 years from the date of the judgment is an instance of, and an extension to the principle of prospective overruling. In Karunakar case, 1993, the Supreme Court held that benefit of the decisions would be given only to the parties to the cases pending before the authorities from the date of the 70 Ibad. Kesavananda Bharti vs. State of Kerala, 1973. Indra Soni vs. Union of India, 1992. Managing Director, ECIL, Hyderabad vs. B. Karunakar, 1993. Judgment but not to the actions already taken by the date of that judgment. Doctrine of harmonious construction. Meaning of the doctrine: when different provisions of the Constitution are found to be in conflict with each other, the courts should interpret them harmoniously so as to avoid the conflictual implications between them. This is known as the doctrine of harmonious construction. This doctrine is also called as the rule of avoidance of conflict. While explaining the doctrine of harmonious construction, Justice Venkatrama Iyer observed, in case of two irreconcilable provisions, they should be so interpreted that effect can be given to both and none of the two is rendered nugatory. Similarly, Justice Mukherjee said, if certain provisions in the Constitution appear to be in conflict with each other, these provisions should be interpreted so as to effect a reconciliation between them so that, if possible, effect could be given to all. The doctrine of harmonious construction should be understood in the light of the following points. 1. The court should read the Constitution as a whole and take into consideration its different parts. 2. The court should proceed on the presumption that no conflict between the different parts was intended by the Constitution makers. 2. Application of the doctrine. The Supreme Court has applied the doctrine of harmonious construction to reconcile the conflict. 1. Between the fundamental rights and directive principles of state policy. 2. Between different fundamental rights. Sri Venkataramana Devaru vs. State of Mysore, 1957. A.K. Gopalan vs. State of Madras, 1950. 3. Between fundamental rights and legislative privileges. 4. Between fundamental rights and amendment procedure. 5. Between fundamental rights and other parts of the Constitution. And 6. Between different entries of the legislative lists in the 7th schedule. The Supreme Court, on the application of the doctrine of harmonious construction to the fundamental rights and directive principles of state policy so as to give effect to both as much as possible, made the following observation. Although in earlier decision the court paid scant regard to the directives on the ground that the courts had little to do with them since they were not justiciable or enforceable like the fundamental rights, the duty of court in relation to the directives came to be emphasized in the later decision which reached its culmination in the Kesavananda Bharti Case 3, 1973, laying down certain broad propositions. Law of these is that there is no disharmony between the directives and the fundamental rights because they supplement each other on aiming at the same goal of bringing about a social revolution and the establishment of a welfare state, which is envisaged in the preamble. The courts, therefore, have responsibility in so interpreting the Constitution as to ensure implementation of the directives and to harmonize the social objective underlying the directives with individual rights. Similarly, the Supreme Court, while applying the doctrine of harmonious construction to the interpretation of the different entries of the legislative lists in the 7th schedule, made the following observation. It is also well settled that widest amplitude should be given to the language of the entries, but some of the entries in Ranjan Dwivedi vs. Union of India, 1983. Kesavananda Bharti vs. State of Kerala, 1973. Calcutta Gas Company vs. State of West Bengal, 1962. The different lists or in the same list may overlap and sometimes may also appear to be in direct conflict with each other. It is then the duty of this court to reconcile the entries and bring about harmony between them. In this way, it may, in most cases, be found possible to arrive at a reasonable and practical construction of the language of the sections, so as to reconcile the respective powers they contain and to give effect to all of them. It is only when such a reconciliation proves impossible, then, and only then, should the overriding power of the Union legis latere, the non-obstant clause, operate and the Union power prevail. 3. Important cases. The important cases relating to the doctrine of harmonious construction and their judgments are given in Table 91.6. Doctrine of liberal interpretation. Meaning of the doctrine. According to the doctrine of liberal interpretation, the Constitution must be interpreted in a broad and liberal manner and not in a narrow or pedantic sense. In other words, a broad and liberal spirit should inspire the interpreters of the Constitution. The doctrine of liberal interpretation envisages that the Constitution should be interpreted not as a mere law but as the machinery by which the laws are to be made. It assumes that the Constitution is a living and organic thing and hence, it must be interpreted broadly and liberally. While explaining the doctrine of liberal interpretation, Justice Higgins made the following observation 5. Although we are to interpret the words of the Constitution on the same principles of interpretation as we apply to Attorney General for New South Wales vs. Brewery Employees Union, 1908. Any ordinary law, these NY ordinary law, these very principles of interpretation compel us to take into account the nature and scope of the act we are interpreting, to remember that it is a constitution, a mechanism under which laws are to be made, and not a mere act which declares what the law is to be. The Supreme Court has explained the doctrine of liberal interpretation in the following way. A constitutional provision is never static, it is ever evolving and ever changing and, therefore, does not admit of a narrow, pedantic or syllogistic approach. It seems well settled that constitutional provisions must receive a broad interpretation, and the scope and ambit of such provisions, and in particular the fundamental rights, should not be cut down by too astute or too restricted an approach. With respect to the application of the doctrine of liberal interpretation to the entries enumerated in the legislative lists under the Life Insurance Corporation of India vs. Manubhai D. Shah, 1992. 7th Schedule of the Constitution, the Supreme Court observed as follows. The cardinal rule of interpretation is that the entries in the legislative lists are not to be read in a narrow or restricted sense, and that each general word should be held to extend to all ancillary or subsidiary matters which can fairly and reasonably be said to be comprehended in it. The widest possible construction, according to the ordinary meaning of the words in the entry, must be put upon them. In construing the words in a constitutional document conferring legislative power, the most liberal construction should be put upon the words so that the same may have effect in their widest amplitude. 2. Doctrine of literal interpretation. The doctrine of literal interpretation is also known as the doctrine of strict construction or the doctrine of positivist construction. According to this doctrine, the provisions Allel Hotels and Investments Limited vs. Tinian of India, 1989. Of the Constitution should be expounded in their plain, ordinary, natural and grammatical meaning. While laying down the doctrine of literal interpretation, Justice Mukherjee said, in interpreting the provisions of our Constitution, we should go by the plain words used by the Constitution makers. The doctrine of literal interpretation says that the Constitution must be interpreted with reference to its terms and those alone. Nothing is to be read into it on grounds of some supposed spirit pervading the Constitution, or on the ground of policy, or even for the purpose of supplying omissions or of correcting errors. 9. The Supreme Court, in the above context, made the following observation. The courts are not at liberty to declare an act void because in their opinion it is opposed to a spirit supposed to pervade the Constitution but not expressed in words. Where the fundamental law has not limited, either in terms or by necessary implication, the general powers conferred upon the legislature, courts cannot declare a limitation upon the motion of having discovered something in the spirit of the Constitution which is not even mentioned in the statute. It is difficult upon any general principles to limit the omnipotence of the sovereign legislative power by judicial interpretation, except so far as the express words of a written constitution give that authority. Doctrine of purposive interpretation. The doctrine of purposive interpretation says that the courts, while making an interpretation of the Constitution, should look into the purpose for incorporating a provision in the Constitution. It emphasizes that the Consti. Chiranjit Lal Chaudhary vs. Union of India, 1950. In presidential reference to the Supreme Court with respect to the Sea Customs Act in 1963. A.K. Gopalan v.S. State of Madras, 1950. Important Doctrines of Constitutional Interpretation. 671. Constitutional interpretation should ascertain the intention of the makers of the Constitution. The preamble to the Constitution and the Constituent Assembly debates throws a light on the purposes of the constitutional provisions and the intent of the Constitution makers. Sir Alladi Krishnaswamy Iyer, a member of the drafting committee of the Constituent Assembly, said, "The preamble to our Constitution expresses what we had thought or dreamt so long." Similarly, in the Birubari Union case, 1960, the Supreme Court said that the preamble is a key to the minds of the makers of the Constitution. While making an argument in favor of the doctrine of purposive interpretation, the Supreme Court made the following observation. Constitutional provisions are required to be understood and interpreted with an object-oriented approach. A constitution must not be construed in a narrow and pedantic sense. The words used may be general in terms, but their full import and true meaning has to be appreciated considering the true context in which the same are used and the purpose which they seek to achieve. Similarly, the former Chief Justice of India, J.S. Verma, while advocating the doctrine of purposive interpretation, said as follows. The Constitution is to be interpreted as a living and vibrant organism to provide for the current societal needs. Constitution is to be construed as enacting concepts. In construing a provision of the Constitution, the constitutional purpose it is meant to subserve has to be borne in mind. In presidential reference to the Supreme Court with respect to the Birubari Union and exchange of enclaves in 1960. S.R. Chowdhury v.S. State of Punjab, 2001. J.S. Verma, New Dimensions of Justice, Universal, 2000, pp. 1-2. Doctrine of Creative Interpretation. The doctrine of creative interpretation envisages an innovative judicial interpretation of the provisions of the Constitution. This doctrine says that the courts should evolve new concepts and new procedures in order to meet the requirements of the changing situations. The judgment delivered by the Supreme Court in the Golak Nath case, 1967, is an important illustration of the doctrine of creative interpretation. In this case, the Supreme Court embarked on a creative role by introducing for the first time in India the American doctrine of prospective overruling. According to this doctrine, an old precedent, stare decisis, can be overruled from a future date and not retrospectively. While asserting a creative role for itself in the Golak Nath cases, 1967, the Supreme Court made the following observation. Articles 32, 141 and 142 are couched in such wide and elastic terms as to enable 1. C. Golak Nath vs. State of Punjab, 1967. 95 Ibid. This court to formulate legal doctrines to meet the ends of justice. To deny this power to the Supreme Court on the basis of some outmoded theory that the court only finds the law but does not make it is to make ineffective the powerful instrument of justice placed in the hands of the highest judiciary of this country. Another significant manifestation of the doctrine of creative interpretation is the judgment delivered by the Supreme Court in the Kesavananda Bharti case, 1973. In this case, the Supreme Court innovated a new constitutional doctrine called the doctrine of basic structure of the Constitution. In fact, this judgment is regarded as the watermark of the judicial creativity in India. 96 Kesavananda Bharti vs. State of Kerala, 1973.